Good day, ladies and gentlemen. Welcome back to CrimLawTV. Today we're going to discuss case law in Virginia for September 2010. So let's get to it.
The number you have reached, 911, has been changed to a non-published number.
Good day, ladies and gentlemen. Welcome to CrimLawTV. I'm your host, Ken Lammers, and we're going to start out talking about the different changes in law, or case law, in September 2010. We're going to start with the constitutional cases. First of all, in the Fourth Amendment, we had Foltz against Commonwealth. Now, I'm not going to talk about this case much because it was taken en banc, so there'll be a whole new opinion shortly. Except to say a couple things. First of all, Foltz was a case where they were tracking a guy with GPS without a warrant. They detached it to the back of his bumper, and it wasn't his vehicle. It was actually the vehicle that belonged to his boss or his workplace. So I'm not sure how he asserts Fourth Amendment rights. There probably is some case law out there for that. But moving beyond that, the rationale, at least part of the rationale, was that that there was no constitutional violation for placing the GPS tracker underneath the bumper, was that there is no societal interest in protecting the privacy of those activities which might occur in a bumper. That's right. You heard me. There's no societal interest in protecting, what happens back behind that bumper, so you can place that GPS tracker there. Much as I've said previously, that's like saying in cats, well, there's no societal interest in protecting, what happens on the outside of a phone booth. Well, I'm sure that the Court of Appeals will reconsider that in their en banc and probably come up with better rationale. I don't expect that to be overturned, mind you. Next, we get the Fifth Amendment. In the Fifth Amendment, we get Andrews against Commonwealth, and talk about, it's a double jeopardy issue. They talk about if the Commonwealth indicts on two non-compatible indictments, which they can do, and in this case it's about capital cases. They can indict for capital murder under one theory and capital murder under another theory. In this case, capital murder, multiple killings in one act, and capital murder, multiple killings within a 3-year period. The Commonwealth can indict for both of those. However, should the jury convict on both of those, the Commonwealth must elect one of them to proceed to punishment under, because it can't punish both of them, because that will violate double jeopardy. And the way that the Court of Appeals gets there, it says, well, look, there's Blockburger, but before you get to Blockburger, you got to look at legislative intent, and the first test is whether the legislature intended for these two crimes to be punished at the same time. And they say, no, they didn't intend here. When they passed the multiple murders over a 3-year period, they didn't mean for that to encompass, the multiple murders in one act. So therefore, they're different crimes, not intended to be punished at the same time, and double jeopardy attaches. The Commonwealth has to choose which one to be punished under. That was Andrews against Commonwealth. Now in the Fourth Circuit, we get U.S. against White. Now this is a due process decision, and it talks about individuals having a right not to be forced to be medicated to be brought back to competency. They talked about there has to be a significant, forced return to competency. It's supposed to be something done rarely. They talk about the 4-factor test and whether or not a criminal defendant can be forcibly returned to competence. First, the government must show that there's an important governmental interest and that there are no that special circumstances do not mitigate against that governmental interest. Second, the medication must be substantially likely to make the defendant competent and able to help their defense counsel, and substantially unlikely to have side effects which would make them unable to help their defense counsel. Third, there cannot be less intrusive means of achieving the same result. And fourth, the medication, the forced medication, must be in the patient's best interests, must be medically appropriate, and that's basically the test. So you get those four, and basically then they go on and say, look, if it carries a punishment of 10 years or more, then that's a substantial governmental interest. So this is a crime that carried a punishment of over 10 years. It carried a substantial governmental interest. Then they list a whole bunch of possible mitigation circumstances, not limited to these, but these are the ones that they discussed. Possibility a defendant might be confined to an asylum, mental asylum, if not convicted. Potential for future confinement if the defendant is restored to competency. Possible punishment if they're competent in the criminal system. The fact how much time the defendant has already been confined for compared to what she could get sentence-wise, and whether the crime is a violent crime. Basically, they go on and say if the defendant has already been in prison for the entirety of her sentence, or what her likely sentence would be, that's a significant mitigation against forcing her to be medicated back to regularity, back to competency. And the treatment must be shown to be effective on the problem that the person has they're trying to restore to competency. In this case, they both showed that, look, her likely sentence is about what she's already done. She's in a mental institution now, a prison mental institution, and there's no real proof that the treatment that they're proposing forcing on her will work. So they rejected it at this point. Rejected forcible medication. Now we move on to the Sixth Amendment, the right to confront the accuser. That's Aguilar against Commonwealth, and this hopefully will be the last of the right to confront cases coming out of Melendez-Diaz. This was there are two cases that were rejected from after Melendez-Diaz and sent back to Virginia Supreme Court. Aguilar is the one that basically says, look, if there's a supervisor who looks at the analyses itself, looks at the data himself, and independently on his own does, comes to a conclusion and puts it on the certificate of analysis, and that supervisor is available to testify, then it fulfills the confrontation clause. It says, not bringing in technicians or whomever might have worked on it and might have contributed somewhat is not a violation of the confrontation clause, but it can't go towards the weight of the evidence presented. Even if other technicians worked on the evidence to get the results, it's admissible if the testifying witness supervised the work, reviewed the materials, drew his own conclusions, and did not include any statements from any of the other technicians that worked on it. If an expert only puts the conclusions of a technician, of course it's not allowed in. But if he reviews it himself and comes to a conclusion and puts that on the certificate of analysis, it is. Briscoe against Commonwealth, which was Magruder against Commonwealth when it went up through the Virginia courts, and it got bounced from the Supreme Court of the United States. And basically this all deals with the old statutory scheme in Virginia, so I'm not going to go over it since that statutory scheme doesn't exist anymore. It was changed by the General Assembly.